I want to bring in Scott Sunby, a professor at the University of Miami School of Law, as well as a jury researcher with us today as well. So, Scott, I just want to start by asking, now that there's a break in the courtroom, on what it is that the jury sees when they go from a Stormy Daniels and then Westerhout to now an AT&T specialist to give you an understanding of what SMSI means. In other words, how does the jury relate to that?
So I think most jurors are going to be looking at that as something that the lawyers are doing for the judge's benefit in many ways. And as Catherine was saying, this is sort of setting the evidentiary foundation for the phone calls to come in, which are going to be essential to corroborating Cohen. And eventually, I think that they'll see how it ties back up. But I'm sure that they're scratching their head. They may actually be even enjoying a little bit of a break from having to listen to some far more entertaining details, but far more intensive, right?
And so, Catherine, I mean, the prosecution, as we were just talking about this, they did object to a lot of questions that Trump's attorneys were asking Westerhout, Madeleine Westerhout, different from how the defense acted and the objections that they did or did not bring up during Stormy Daniels' testimony. What do you make of that?
Attorney style, you know, the defense, and in that case was Ms. Nicholas, should have been objecting more to the Stormy Daniels testimony. It's just, when I say style, because different prosecutors have different witnesses and different defense attorneys have different. So there's nothing wrong with objecting. If you believe a question is irrelevant or is going to bring out inadmissible testimony, you should object, whether you're the prosecution or the defense. I wouldn't take it like a tit for tat, who objected more. It really doesn't say much about, you know, what's going on.
Catherine, how would you, I guess, rate the amount of objections that we have seen from the prosecution and then from the defense as far as vis-a-vis other kind of criminal trials? Are there less objections by the defense? It's something that even Juan Merchang, the judge, mentioned to the defense.
Well, there were, for just Stormy Daniels' witness, they objected a lot before. So I have to say, from different trials are different, and different defense attorney styles and different prosecution styles. My style as a prosecutor was to only object when something was clearly irrelevant and inadmissible and over the line, because I always did not want the jury to think I was hiding something from them. Now, if it was something that the defense was trying to elicit that was already ruled upon, you better believe I was standing up and objecting. So there are different styles. I don't think you can say, you know, how many objections from the defense, how many from prosecution, and then sort of rate that. I think this case is normal. People were upset. People were commenting on the opening statement that the prosecution objected, and that's unheard of. You know, it's not unheard of. At least in New York State court practice and in that courthouse, defense attorneys will make openings and prosecutors will object because, you know, they go to the line. And there's nothing wrong with that. And the jury is not saying, oh, my goodness, the prosecution objected, the defense must have done something bad. Because if that's the case, then they're going to be looking at the prosecution saying, you know, when the defense objects, uh-oh, the prosecution might be doing something bad. I think jurors are much more sophisticated than that. They are instructed under the law, and not just to focus on the evidence, not, you know, counting the scorecard about how many objections each side has made.
And so, Scott, Madeleine Westerhout admitted to prosecutors that she spoke with Trump's lawyer, Susan Nicholas, 2 nights ago. Is it unusual for a prosecution witness to meet with defense attorneys?
So it really depends on the state and the situation. In Florida, we actually have depositions of witnesses that defense attorneys can take. So, you know, that would be in a much more formal setting. As far as I am aware, I think that is rather unusual that someone who is a prosecution witness is meeting with the defense attorney. There's nothing that, you know, ethically keeps them from being able to do that. But usually each side side sort of views their witnesses as their witnesses, right? And carefully instruct them that you don't have to talk to the other side. You can if you want, but you don't have to.
And so right now, and we were hearing from Vaughn Hilliard just at the top of this hour, how there was a discussion between the prosecution and defense and the judge about a CNN interview that Trump did with Larry King when he was talking about, all kinds of issues of election issues and election law. And Merchang right now, as a matter of fact, is coming back and he's saying, I understand what you're saying about the laws of 1999 compared to 2015 to 2017, so I will side with the defense on this. We have 2 more witnesses, the judge says. How long do you expect this to go? Mangold said, about an hour. Merchang, so we will work until a bit after 1, so we don't need to come back after lunch today. So, Scott, let's take it to the jury. And the jury is hearing, as I say, from this, and Catherine was talking about how boring but important testimony, and I think that somebody from AT&T explaining what a chip, a SIM chip is and how it works is certainly not of the interest to most people. What is it that you, as a prosecutor, keep in mind when you're bringing up these different witnesses who have peaks and valleys, I guess, of storytelling?
Yeah, and storytelling is exactly right, Jose. I mean, and the best attorneys, whether prosecutors or defense attorneys, are master storytellers. And one of the things that is so challenging as an attorney is we are used to giving a narrative, right? If we tell a story, certainly when I teach, right, I'm able to, weave chronologically as it fits me. Lawyers have to call witnesses to tell their stories. They get the opening, they get the closing, but in between you are calling, it's almost like calling characters out of a novel and saying, tell us what you know about this. And it doesn't necessarily flow real smoothly, and it can be very difficult to sort of construct that narrative in a way that the jury would understand. Now, these less sexy witnesses, if we can put it that way, are, they're probably interspersing them in part because we had Stormy Daniels, which had, I'm sure, the jury riveted. We will have Michael Cohen, as I understand it, next week, which will have the jury riveted. So for a half day on a Friday, this is a chance to almost do some evidentiary bookkeeping, if you will, for the prosecution. We have to get this in. These are going to be important, just tie up that Michael Cohen had those phone numbers and was calling them. But it's part of sort of the background story that the prosecution has to get in to get to the main story.